Hi, I'm Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and this week's contract tip has to do with surveys and contracts. So if a seller has an existing survey to the property, it is going to be their choice if they want to attach it to the contract and make it a part of the contract or not. And this issue also depends on which contract under which the buyers and sellers are binding. If they are binding under the GAR contract, make sure the sellers understand how that survey may or may not be used contractually. And in the RE forms, I'll get to that in a minute. But let me tell you what it says in the GAR contract. On paragraph A2, it specifically states survey. A survey of the property is or is not attached as to this agreement as an exhibit. And you, the agent, fill out if it is or is not attached. Now, again, depending on which party you represent, if you're representing a seller, you want to have a discussion with them regarding do they want to attach a survey or not. So you turn around and read paragraph B2. And that states, notwithstanding any provision to the contrary contained herein, the buyer shall have the right to terminate the agreement upon written notice to the seller if a new survey that the buyer gets, as long as it's performed by a licensed surveyor licensed in Georgia, is materially different from the seller survey that is attached to the contract and made a part of the contract. The term materially different shall not apply to improvements or repairs constructed by the seller in their agreed upon locations subsequent to the binding agreement date. Matters revealed in any survey, including a survey attached hereto, may be raised by the buyer as a title objection. So if the parties are binding under the GAR contract, if a seller attaches a survey, an existing survey, and makes it part of the contract, it potentially does give a buyer termination rights depending on what the survey shows in and of itself. And if a buyer gets a new survey, which all buyers should be getting a new survey of the property they're buying, if their new survey does show something materially different from the existing one. In the RE forms contract, a survey is not mentioned at all in the actual purchase and sale or in the standard terms to the RE forms contract. However, there still may be title if a survey is attached to the property and it raises some title issues that could potentially, the buyer does have rights. The seller must convey clear title at closing, regardless in both the RE forms contract and the GAR contract. So just a quick tip, make sure your parties understand what contractually happens if a survey is or is not attached to part of the contract. Again, I'm Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.